All right, so there you go. That's 30 seconds of my time. I'm going to assume that everyone here is somewhat familiar with the Digital Millennium Copyright Act and how notice and takedown works. If you're not, I'm happy to answer questions as we go or at the end. But you know, it just feels kind of silly for me to really explain so many basic things. So I have 1,000 titles for this paper. These are some of them. Here's my thesis. I think that in the online world, the balance struck by the traditional levers of copyright policy, and I'm of course thinking of things like the idea of expression distinction, fair use doctrine, other things, that they've been superseded by the DMCA safe harbor system. That they are in fact increasingly irrelevant to our online lives, and of course our online lives are an increasingly significant part of our lives, politically, socially, in all these respects. I actually think that this could be a good thing. In order to try and explain the DMCA and to think about the DMCA, and really as a mechanism to introduce it to people who are not that familiar with it, I have a sort of framework of analysis that I think might be helpful. The beginning of the framework is to classify the relevant actors in terms of traditional producers of copyrighted content. Think of those people who think of themselves as professional copyrighted work creators. The second set of players are online platforms. Primarily, I'm thinking about entities such as YouTube, Facebook, social media, any kind of internet platform that is somewhere where users can place their own content. And then we have users. The other part of my framework is that I think it's helpful to think about the DMCA in terms of what I call first-order effects and interaction effects. Now, I'm just abusing the hell out of these terms, so I'm sorry about that. But what I really mean is look at the legislation and look directly at the incentives that it creates. And that's not the effect of the DMCA. The interesting effect of the DMCA is when you see how those incentives interact. So let me briefly try and explain some of this. First order effects for online platforms. Notice and takedown gives platforms an incentive essentially to reflexively comply with a facially valid takedown notice. If it looks like a good notice, you just take the material down. Pretty much everyone does that. They also have an incentive to terminate repeat infringers identified in said notices. So not actual repeat infringers, like those who are identified in the notices. And they have an incentive, a pretty weak incentive, to restore the work or unblock the work if the alleged infringer issues a counter notification, which almost never happens. They also have a negative incentive. They have an incentive to refrain from acquiring actual knowledge of infringement. And there are some conspicuous gaps in their incentives here. They don't actually have an incentive under the DMCA to filter. There's no filtering mandate. There's no mandate to discourage infringement. There's no mandate to design a system to minimize infringement. Traditional producers, I'm thinking of the Viacoms of this world, they have an incentive under the DMCA to monitor for possible infringement and issue notifications. They have an incentive to refrain from issuing takedown notices that are so obviously erroneous that they would be found to be subjectively in bad faith. This is a very hard standard to satisfy. Other than that, they really have no reason to be that careful about their takedown notices. And of course, they have no cause of action against these safe harbored platforms. That's the whole point of the safe harbor. It gives people like YouTube who play by the notice and takedown rules, it gives them a safe harbor. Users, I guess, have an incentive to counter-notify, but again, rarely used. They have an incentive to take an action for an abusive takedown notice under 512F, but actually what the DMCA gives there, it also takes away, because 512F will only get you so much, and it preempts all of your state law causes of action that you might have had. And in terms of conspicuous gaps, the DMCA does not change the user's underlying liability. So those are the first order effects, or the actual incentives created by the text of the DMCA. Now I want to talk about the interaction of these incentives. So let's look at the interaction of platforms and users. And this is this has been well commented on and established. The DMCA doesn't really do anything to directly encourage users to be creative, to be generative. But it encourages platforms to be open, and that openness in turn has sparked a wealth of user creativity and user generativity. The lack of prior restraint, compared to a system of publishing your work through going through a respectable offline middleman, possibly changes the normative framework. My theory of copyright and fair use is that most of what we think of as fair is just a question of that which we regard as normal, that which we are used to seeing. And if that's right, then the fact that these platforms are wide open and users have an enormous amount of freedom, that might be significant. In terms of traditional producers and online platforms, notice and takedown is what's in the DMCA. Nominate and monetize is really the regime that we're shifting to. What do I mean by nominate and monetize? I mean systems like Content ID, where producers provide platforms with samples of their works that they say, we own these works and we don't license people to go put them up on your service. They take a digital fingerprint, and then when those things appear on YouTube nonetheless, the content owner is given the choice typically of monitor, monetize, or block. That's in the Google speak. Notice and takedown doesn't really scale. Like, it was a system, when it was first devised, we had a very small number of notices. I don't know how many notices are being issued these days, but it's been an exponential curve. It actually imposes significant costs on platforms as well as on producers. And for the platforms, they can just sit back and play the notice and takedown game and be content with the fact that a lot of content is left standing. But there's a strong incentive for them to be more cooperative as long as the producers are willing to not block everything but monetize some of the content. So nominate and monetize seems to be an equilibrium that the major players are converging on. And apparently Facebook is about to introduce its own Content ID soon. It's not just Content ID, there's also bulk removal systems, essentially an express notice and takedown system for producers who've shown that they're going to be accurate and non-abusive. I think also graduated response fits into this framework. These are all things that reduce the cost of administering notice and takedown. And I think I'm just going to skip over the next one. So, nominate and monetize, I think, is increasingly the world that we're left with under DMCA. To me, it seems that this was inevitable. And the point I want to make is that the argument, the classic argument fought out in the Viacom versus YouTube case was never about, would there be filtering? The argument was about, from which default would filtering be negotiated? Producers see Content ID as this thing that they agreed to with a gun to their head. Other people have suggested that the gun was pointed in the other direction, noting that all this filtering technology was adopted during the course of litigation, arguably defensively or to defend against changes in Congress to the notice and takedown regime. And for someone like Google or Facebook, you're just better off introducing filtering than putting up with something devised at the Library of Congress that mandates a technological solution. If you agree that some kind of filtering compromise was inevitable, then these sort of normative arguments based on a comparison between no filtering and filtering, that it just doesn't seem like the right comparison in a welfare analysis. And I think the real question is, what kind of balance of accessibility is left by these filtering agreements? And that still depends very much on what the baseline was. If the baseline is there's a technological mandate in the law to adopt filtering, then of course I think we're going to see much more restrictive filtering. So it's not that the baseline rules, as we saw in the Viacom case, are unimportant. They're just not the end result. Voluntary filtering is better. That's just an a priori commitment that I probably don't have time to defend here. There is absolutely no guarantee of due process once we shift from notice and takedown to nominate and monetize. And that is something that some people find quite disturbing. I think you have to acknowledge that platforms have an incentive not to completely shut down the speech opportunities of their users. On the same point, though, you have to acknowledge that Google's interests are not our interests, right? There is a definite misalignment in interests that we cannot completely trust these platforms to have our interests in mind, even if they insist on some level of openness for their own reason. And filtering is ultimately a form of prior restraint, but there's no con law remedy here. This is, we've established a system that gives commercial actors an incentive to engage in prior restraint. If that restraint was done directly by the state, there would be First Amendment implications. I think there are free speech implications here, but I don't think there's any First Amendment violation. And now I want to come back to the sort of the normative framework here. I think that open platforms in the past decade and a half have really enlarged the public conception of fair use and the appropriate limits of copyright. That is a statement that is empirical, for which I have no evidence other than my own intuition and sense of talking to people, so it's probably wrong. But if it's not wrong, then it's exactly opposite to Jim Gibson's risk aversion and rights accretion thesis, which is similarly anecdotal, although probably better reasoned. But of course, you should expect something different here, because the key to Jim's thesis is the role of gatekeepers. Gatekeepers as risk-averse entities. Whereas, of course, under the DMCA, gatekeepers have no incentive to keep the gates. Right? That's the only thing they do is respond to notice and takedown. I am running short of time, so I'm going to skip that point. Just a couple of concluding points I want to make is that the balance of what you could publish used to be determined by these gatekeepers responding to their understanding of what copyright law allowed. These understandings were laden with risk aversion, they were imperfect, they were probably biased, but they were, in some sense, tethered to what copyright law was, and occasionally we would resolve conflicts through gladiatorial contests, where the Campbells of this world would do battle with the Acuff Roses of this world, and that would kind of set the rules for everyone who fell roughly in these two camps. That's not the system that we have now. This is the system that we have now, is we have zombie armies of infringers, people who don't know and don't care about the substantive content of copyright, and we have, robot machine guns of notice and takedown, and the robots through nominate and monetize, who mow down everything they can see, but that still leaves a lot standing. And my point is essentially, that's a very different system. It's not clear that it's a worse system than in the offline world. And I should probably take questions. And feel free to email me your outraged comments as well. I would really appreciate them. Yes?
So I just moderated the ABA annual meeting panel on DMCA. So there was somebody from Google, Twitter, and RIAA. A couple interesting facts. I'm talking about scale. Mm-hmm. Google is processing 1 million notices a day, most of which are automated using robots. So they're not even, there's some human inspection, but obviously very little human inspection of the notices. And the content producers are also, they're sending out millions of notices a day too, so it's a huge scale. I guess I might push back on your framing of this as not being the what the DMCA intended. There's a way to, I think, to read legislative history as one of the goals as encouraging sort of voluntary cooperation among ISPs and copyright owners. So one of the questions that I asked the panelists was, do you want to change notice and takedown? No one really wanted to change it drastically. They like this they like the system enough that they want to do all these voluntary measures that you rattled off. And so that they're happy with it, but there's a way to, I think, to characterize what's going on as maybe not completely against what Congress had intended, to leave it to the stakeholders to figure out something that was working within this framework of notice and takedown.
Okay, that's a good point. Yes.
All right, so the first question is, I'm having trouble as you talk pinning down whether you think that this system ultimately leads to broader effective scope of what people can do under fair use or narrower effective scope. At times I thought you had one hypothesis, at times I thought you had the other. And maybe that's the central empirical question of your paper. I don't know. Do you have a leaning towards one of those or the other, or is it an empirical project to find out?
No, I think the effective scope of fair use and tolerated use, which could be different, is practically, it's much broader than it used to be. But if you think of it, maybe the average is higher, but the variance is probably higher as well. I mean, you have, John McCain's political ads get subject to a takedown notice in the middle of an election that would not survive the laugh test if it was submitted straight to a commercial broadcaster's legal department. So, it's not, there are winners and losers here. One question is, well, what's the aggregate? And that might even be the wrong question. Maybe the right question is, what is the regime that results in the least extreme restrictions of speech ever? We can have different normative commitments on this.
And then the next, if I can
quickly.
All right. It seems like there's another dynamic which might belong in your story too, which is so there's bargaining under the shadow of the rule that's happening between the producers and the platform, but there's also bargaining in the shadow of the rule that's happening between producers and users. And I'm thinking of an organization that's done something that seems like fair use to me, that has a copyright demand where they've said, now we're not asking Google to take this video down in an effort to resolve it amicably, please pay this amount, right? And then there's the statutory damages threat over the head, right? So there's this there's another shadow world of bargaining happening alongside the system that you're describing here.
Yeah, that's interesting. I'll follow up with you on that. Yes?
So the bottom line, what you're saying seems to be Google decides at the end of the day according to the interest of Google. Is that a good thing? Do we have any alternative to that?
Yeah, I think that is one of the most troubling things. It's not just that it's Google deciding, it's the people who program the robots at Google deciding. And that is, there are some obvious reasons to be concerned by that. Yes?
So I was wondering, to what extent, with respect to the nominate and monetize, to what extent is that contractual and to what extent is that informed by copyright law? Specifically, let's take a video that I post that has some clip in it that every expert would agree is fair use. Does the current contractual arrangement basically say that will be subject to this monetization compensation to the clip owner? Without regard, even if it's fair use, even if it's absolutely clear, it's legally fair use. Is that true? And
so I'm not privy to those contracts.
Right.
But
wait, aren't they in the user agreement though? They have to be in the user agreement.
Between you as the poster.
Yeah, I posted. I have to see it to agree with it. I think we.
Oh, we haven't. Yeah,
we haven't watered down.
But that's not the relevant agreement, because the platform reserves the right to run ads based on your content. It's just a question of.
They don't agree with me as to who they pay money to.
Yeah. Yeah. But this is a weird situation of where we might actually be taxing fair uses in a way that doesn't actually take away from people's ability to make those fair uses, in which case probably we should be okay with that. Okay. I'm out of time.